Welcome to this webinar on assignment and novation, although it might actually look at the top of your screen saying it's WRs for collateral warranties, but no, this one is assignment and novation. It's the second part of, I would say, a trilogy. So we might do performance bonds and parent company guarantees next, if we can work out how to make that fill an hour. It's a bit like a Star Wars trilogy, but slightly more dull, but you do have your own Harrison Ford lookalike. That's me, by the way. I don't know what Darth Vader's called Rory, but that'll be Rory. That's that. How is this going to work? Let me just see. Right, there are three of us today. Some of you have been on these webinars before will recognise me at least. I'm going to do the part on novation. Sarah, whose face remains enormous on the picture, and despite what it looks like, she does actually have some clothes on that picture. She is going to do assignment, and Rory is going to talk about how the novations work in a sort of procurement basis, what type of novations occur and what you can expect to see. Before we move on to assignment and Sarah, if you've got any questions, please put them in the public chat. Feel free to send me private messages about your own personal problems, but for purposes of asking questions about novation and assignment, you want to put in the public chat. Also, you will see that there is a City of London Law Society novation agreement on your screen. Unlike the collateral warranties talk, we're not going to sort of spend a long time looking at the particular clauses, but it's a very useful document from a novation perspective. I do talk about it a bit. So it's one of those documents that if you are involved in this sort of stuff, it's useful to have because it sets you a very sort of sensible precedent basis. So without further ado, and without any more really bad gags, I'm going to pass you over to Sarah, who is going to talk about assignment. We're going to move seamlessly the screen as we do.
Thanks,
over to you, Sarah.
You'll be pleased to see I am also wearing clothes today. So for the first part of the webinar, we're going to focus on assignment, as Andrew said. I'm guessing that most of you are aware of that term or have probably heard it because it's a feature of most construction contracts. So we're going to run through what it actually means, how and when contracts are typically assigned, the different types of assignment, and how assignment tends to be limited, and what really you should be looking out for in a typical assignment clause in your contracts or appointments. So the key thing to remember about assignment is that it is the transfer of a benefit of a contract, and it doesn't transfer the burden. So, for example, if, say, a professional appointment is assigned to the purchaser of the whole of a development after completion, the purchaser will be able to rely on all the benefits of that contract. So they'll be able to rely on the fact that the consultant has provided their design with reasonable skill and care, and if they've failed to do that and there's defects, they'll be able to bring a claim. What won't happen is if the consultant's owed any money under the original appointment by the employer, the purchaser doesn't take on the burden of that, so they don't then owe the consultant any money. That still remains with the employer. So it's only the benefit and not the burden that's taken on after assignment. So on the slide is a fairly typical assignment clause. It's probably something that you've seen. As I said earlier, this is a feature of most, if not all, construction contracts. Generally speaking, the right to assign will be limited to two parties without the consent of the consultant in this example, I think, being required. This excludes assignments to a funder and assignments to a group company. This is a very market standard position on assignments. The carve-out in relation to funders and group companies is also very typical. That really relates to the kind of usual setup on construction contracts in relation to the funders. Funders will normally require the rights to assign the contract when they give the fund. And in terms of group companies, this just allows the flexibility for the developer to kind of have an internal restructuring of their company, and that not to count as one of their used assignments under the contract. So up on the slide are typical situations where assignments used. We've mentioned most of these already, but first and foremost, purchasers post-completion. So if the developer is getting rid of the whole development, and if the purchaser doesn't have a collateral warranty, which is quite often the case, this will be an assignment will be used post-completion. So the purchaser's got the right to bring a claim against the contractor or the consultant. The next two on the slide relate to the groups who are typically excluded from the limits on assignment that we've just discussed. So the funder, they often require an assignment of the relevant building contracts, and then they have a reassignment on redemption of the loan. So essentially that means that once the building works are completed, there's an assignment at the beginning, and once the works are completed, it's reassigned back to the original employer. On the slide, it mentions that is in fact an equitable assignment, and we'll discuss more on that in a moment. And the final one is where there's intra-group reorganisation. So that just essentially allows the developer to restructure their company should they wish to. The types of assignments. So on the slide, you'll see that there are two different types of assignment, legal and equitable. So for an assignment to be a legal assignment, there are certain criteria that needs to be met. There that the assignment is in writing. The assignment has to be of the whole of the contract or the whole of the appointment. And there must be a notice of assignment given, a written notice of assignment given. As I just mentioned, assignments to funders are likely to be an equitable assignment. This is because the funder is essentially taking the assignment by way of a charge. You'll normally see that in an assignment clause written as a security. And it's not actually possible to legally assign a contract by way of a charge. That will actually only ever take effect as an equitable assignment. So most parties who want to rely on the benefit of an assignment will want it to take effect as a legal assignment. This isn't something that generally we need to be particularly concerned about, unless you're the party who's wanting to rely on the assignment, because it essentially means that if it's an equitable assignment, you can't bring a claim in your own right or in your own name. You'd have to get the original employer under the contract or the appointment to bring the claim and to name you as a party. So they're not always willing to do that. So giving a legal assignment, for those that who are interested, it falls under Section 136 of the Law of Property Act, which sets out the various requirements, which we've already touched on. So if the assignment doesn't amount to a legal assignment, it can still take effect as an equitable assignment. So if there's only a verbal agreement to assign, that can't take effect as a legal assignment. If the assignment is only relevant to a particular clause of a building contract, which is sometimes the case, that can't actually be a legal assignment. That will only be an equitable assignment, and there has to be notice given. So if the benefit of an architect's appointment is assigned from a developer to a buyer, the developer or the buyer must give notice to the architect, and if they don't, then the legal assignment won't take effect. So freedom of assignment. So if the contract is silent, it's often thought that that means there's no rights to assign. Unfortunately, that isn't the case. If the contract is silent on assignment, then generally speaking, for a construction contract, there will be a free right to assign. That right will be unlimited. There are only a couple of exclusions to this, and that's where the contract is a personal contract between two parties or or where it's a public policy not to allow it, say, for example, in an employment contract, but certainly in the construction sense, where the contracts are silent, there will be a free right to assign. Of course, most construction contracts, or almost all that we see, will have assignment rights written into them. These rights can be excluded, so a contract can expressly say that there's no right to assign, and in that case, there won't be a legal right to assign the contract. If you're familiar with JCT, you'll know that the assignment rights under that contract are prohibited without consent. So it's very common to do that. So key things to look out for when reviewing contracts from an assignment perspective. Firstly, that there's actually an assignment clause included in the contract. Most likely that there will be. It's then important to check who it's assignable to and whether it's appropriately limited, with the market standard being 2 assignments without consent, excluding funders and often excluding group companies. And then finally, and as ever, you'd need to check your PI insurance. PI insurance policies quite often limit rights to assign, so it's really important to check that you're within the confines of your PI policy. Otherwise, you risk invalidating it in relation to all assignments, not just part of them. And that is everything on assignments. I'm going to pass you over to Andrew, who's going to speak about novation.
Twist the Prosecco box, as they say. Right, so the difference between, let me just click that button. The difference between novations and assignment, I'll come on to in a moment, but it's often misunderstood, not least because people use words like transfer. So, I'm going to transfer the contract. What does that mean? Is it talking about rights? Is it talking about obligations? And so you're better to use the correct terminology, assign the contract or novate the contract. So moving off from assignment to novation. Novation, I'll come on to, but you need all the parties to agree to it, whereas assignment you just don't necessarily do. So what does it mean is the first point. I'm going to spend quite a lot of time on the case law, of which there is only one case. It's a Scottish case involving a large insolvent main contractor. So surprisingly how relevant it is, but it's the only case that says what and how you interpret a novation. Off the back of that, I'm going to talk about what is meant by ab initio novations and switch novations. Ab initio, I'll come on to what that means. Obviously, being a Latin scholar, as you might have worked out, then I know lots of Latin type terminology. I'm then going to talk about the forms of novation that exist. And then after that, Rory is going to move on to when novation occurs, how it occurs, and what to look out for in any kind of novation. So hopefully that will cover most things we need to cover. So what is a novation? Well, like an assignment, novation is the transfer of an interest from one party to another. However, unlike assignment, novation transfers both the benefit and burden of a contract and requires the consent of all the parties. So the fundamental difference is that you novate obligations, you assign rights. Obviously, when you're novating, you also assign the rights as well, but that's the distinct difference. It is not, it says best practice is almost essential that you have a 3-party. I do apologize. I don't apologize. We have a dog in the office, so the small barking in the background is not Rory. It's Bobo. But there's best practice is essential to have a formal novation. You can, and I'll come on to it. You can have novation by conduct, but you don't really want to be in a world where you're working out whether you have a novation or not. You want to know you've got one or you don't. And perhaps the key point is once the novation has taken place, it extinguishes the original contract and replaces it with a new contract. So, it literally switches the contract from A to B to C to B. So I'll come on to that. But the extinguishing of a contract is what happens when you have an ab initio novation. what do the judges say about novation? Well, there's one very important case on novation, Linden Gardens and Leicester Sludge, not a particularly a nice sounding case, but what that did, both in the Court of Appeal and in the House of Lords, just made clear exactly what is meant by novation. Now, this might sound a statement of the obvious what I've just said, but it's consistently a bit misunderstood. As Lord Justice Staunton said, it's the process by which a contract between A and B is transformed into a contract between A and C. And perhaps the point that people need to remember is what Lord Brown Wilkinson said. I'm assuming these people were actually called sort of Dave or something at home, but the burden of a contract can never be assigned without the consent of the other party, unlike an assignment. So that's the key point. Now, in the construction world, we have a problem. I say we have a problem. We have an issue that we need to get right, and that is, and I make no apology. These are taken from the PLC slides. I'm not trying to claim copyright or whatever. But we have a position in the construction industry where typically, for most novated appointments, because it's typically appointments that get novated, it starts off with the developer employing an architect and the developer employing a contractor. And then there is a novation of the architect or engineer, whatever, to the contractor. So that creates that sort of movement, and it means there's no relationship between the developer and the architect retained, because as we've just seen, it extinguishes that contract, which professionals need to remember, because they are employed by the contractor once the novation has happened. They are not still employed by the architect. And there is, in practice, quite a lot of crossover where particularly professionals continue to advise the developer, even though they are strictly then appointed by the contractor. So this is the issue, and it creates a potential black hole. And the case law on this is all about the black hole. And the best way to do it is say, okay, let's take a scenario that a consultant messes up the design whilst working for the employer. Clearly, consultants don't do this, but certainly knows not on this webinar, but you may have heard of some that have. So that's the first point. The contractor in current market practice, certainly on large scale schemes, will take on full design responsibility, including the design pre-contract. In other words, will take on responsibility for the design carried out by the consultant pre-contract. So if that design is wrong, absent anything else, the contractor does not have a claim against the employer, because the contractor's taken on the risk, and if that design is proven to be wrong, the contractor, that's the contractor's risk. He's theoretically being paid for that. The employer theoretically has a claim against the consultant because the consultant got the design wrong, so therefore we're in breach. But the employer has suffered no loss, because the loss the employer would have suffered doesn't have to be paid to the contractor, because the contractor's taken the risk. So this black hole is created, and it's very much a construction industry issue, is created, comes to the fore, if you want, when the novation system sort of takes place. So the question really is, so on a novation, can a contractor recover his losses that result from the design pre-novation? Well, it won't come as any surprise that the case I want to talk about, Blythe and Blythe versus Carillion, is a case that tells us the answer. Now, it actually tells us the wrong answer. And most commentators think the judge got it sort of wrong. But what it has meant is that if you are going to have an novation going forwards, you make sure you have the very correct set of words to deal with this black hole issue. Now, for those of you that don't know, Carillion at the time were called Tarmac. The structural engineers, Blythe and Blythe, I don't know, but I think they're still around. The employer was called THI Leisure Fountain Park. This was a scheme in somewhere in Scotland. Bog standard appointment between THI and Blythe. That bog standard appointment anticipated a novation to the contractor. standard GCT design and build contract amended such that the contractor took all the risk. Novation took place 1998. This is a fair while ago, but this is the irony of it. This is the only case expressly to deal with how a novation is to be interpreted. So whether we like it or not, at the moment, we're stuck with a Scottish case. What they decided to do, which was actually eminently sensible, which is not that usual for construction litigation, is they decided to hold a test case and ask the judge to assume certain facts. No one admitted these facts were right or wrong, but said on the basis, if this is the case, what would your answer be for the particular type of novation that was in existence? So they assumed that pre-novation, Blythe and Blythe had, as part of their work, I'd say it informed Carillion, but effectively the contractors tendering were given information by Blythe and Blythe via the drawing. It was assumed that that was wrong. And the main issue with this job in practice was that Blythe and Blythe had assumed a certain tonnage of reinforcement, and it was an order of magnitude out. So they'd assumed 500 tonnes and they needed 5,000 tonnes. Carillion, of course, taking on that risk by signing a full D&B. It was assumed for the purposes of the case that Blythe and Blythe were negligent, and it was assumed that Carillion, had they been given the right price, would have, given the right information, would have put in a much higher price. It was also accepted that Carillion took on design risk. So in effect, the party said, look, let's just assume these facts apply. What would be the answer with the form of novation we've got? Because it won't come as any surprise that Blythe and Blythe were arguing that they were not responsible to Carillion for pre-novation breaches, and Carillion were arguing that Blythe and Blythe were responsible to Carillion for pre-novation breaches. So in other words, Carillion were trying to avoid the no-loss argument. Hopefully you can read that. The clauses in the contract said the following. Now, if you read these clauses, it says the liability of the consultant, I'm just going to refer to another screen because my eyes are so bad. The liability of the consultant under the appointment, whether accruing before or after the date of the novation, shall be to the contractor. So that's sort of saying, okay, the consultant's liable to the contractor, whether it's before or after. And the consultant agrees to perform the appointment and to be bound by the terms in all respects as if the contractor has always been named as the party to the appointment. So you might think that actually is dealing with pre-novation breaches. Furthermore, another clause of the novation says the consultant agrees that any services performed prior to effectively the appointment of the contractor will be treated as services performed by and for the contractor. So clause 4 and clause 5, most lawyers, commentators, call it what you like, thought clause 4 and clause 5 amounted to an ab initio type novation. In other words, that Blythe and Blythe would be liable to Carillion for a pre-novation breach. The judge, of course, had other ideas. So he came to the conclusion, and it's not a particular, ironically, even though it's the leading case on novation, it's not actually that easy to find, because it's a Scottish law case, but his comment in one of the paragraphs was, in these circumstances, I've come to the conclusion that the pursuers, now in Scotland they use slightly different language, but the pursuers were Blythe and Blythe, are correct that the defenders, Carillion, cannot claim for their own losses. Not losses conceived as having been suffered by the employer. So he basically came to the point that because the employer had suffered no loss, Carillion couldn't recover their money from Blythe and Blythe because they didn't have the right to recover that under the contract. Part of his reasoning was that it was up to the employer to bring a claim against Blythe and Blythe, and they had no intention of doing so. So this case basically said, if you get your wording wrong, the no-loss problem is a real problem. And obviously Carillion lost a lot of money before they lost even more money everywhere else. So the outcome of the case is the wording was probably okay, but this particular Scottish judge said it wasn't. And whether we all think it's right or wrong, case law takes precedence. And even though it's Scottish case law, which is arguably only sort of persuasive, not binding, there is still only one case. And that one case says, unless you get the wording right, the no loss argument still exists. So what we've ended up with is parties creating various documents that do have the right wording. And it's important that you use those documents and understand those documents when signing up to Novation, depending on whichever side you're on. Obviously, if you're a consultant, I'll come on to this in a moment, you may not want what might be called the Carillion and Blythe wording. But I think you have to accept, and I will come on to where sometimes you won't, but you have to accept that if that's what is required as part of the overall contractual nexus, that is what's needed in that contract. If that's not what's required, then you make sure the wording is not sort of avoiding the no loss argument. So, as I've already mentioned, there are essentially, there's three types of novation, but in practice, ab initio is 98% of those that take place. Ab initio, with my Latin knowledge, basically means from the beginning. So an ab initio novation is if the contract was always the way you've ended up, rather than the original employer professional is deemed to be always contractor professional. Same sort of expression is used before. The effect of an ab initio novation is to extinguish the original contract and create a new contract. So you don't have part contract, part not. You do get what's called a switch novation. Now, a switch novation is not unheard of, but a switch novation is a novation where the novation only takes effect from the date of the novation. So in other words, it doesn't extinguish the original contract. That contract comes to an end, but is not extinguished. It still exists. And a new contract is started from the date of the novation. The problem with a switch novation, hopefully if you're still with me, is it does not give you coverage for any no loss argument that may have been incurred before. So unusual in the construction market, but not entirely unheard of. You can also get novations by conduct, where one party in practice acts for the contractor, having originally acted for the employer, and there's no formal novation agreed. But I would very much caution you against that if at all possible, because it creates huge amounts of money for lawyers and no certainty. So try and avoid that if at all possible. So I want to focus on an ab initio novation because that's what most of them do. And all an ab initio novation needs to do is have 5 clauses. It needs to have a release by the employer to the consultant, so effectively saying to the consultant, we release you from what you did before. It needs to have a release from the consultant to the employer saying, well, I release you from your obligations. It needs to have a clause saying the consultant is bound to the contractor as if they always were, ab initio, and it needs to have a clause that says the contractor is bound to the consultant as if they always were. And on top of that, because of the one case that exists, you need a clause expressly to deal with Carillion and Blythe and Blythe. Briefly, forms of novation. So we've referred you to the City of London Law Society novation. It's free. The next slide, I've actually got the whole novation on the slide. It's very short. It's very correct. It's no fluff. There's nothing like that. You will get bespoke forms of novation, but essentially, provided they have those 5 key clauses, and provided the rest of it isn't doing anything different, then they're okay. So the City of London Law Society has a form of novation, which is ab initio, which is fine. The only other ones really in the market from the CIC, they originally had a switch-only form of novation, which was pretty unhelpful if you wanted an ab initio one. They have subsequently produced an ab initio novation. So there is a CIC form as well that exists, and there's, if it's a pure ab initio novation, that's fine. You also get bespoke forms. So, but the best one to focus on, I would say, just as a sort of learning perspective, is the City of London Law Society novation. Now, this slide is a ridiculous slide, and you probably can't read it, but that is the entire contents of the novation for the City of London Law Society. And it says, if you read it, it says, the employer releases consultant, consultant releases employer, consultant's bound to contractors if they always were, contractors bound to the consultant if they always were, and there's a Carillion Blythe and Blythe clause on that slide, bullet point 3. That's all you need. So from a novation perspective, don't need to overcomplicate it. The CIC switch form is arguably as useful as a chocolate teapot. Not entirely fair, because there are some times where you might use a switch novation. But the truth is, in what we do in construction, and because the contractor needs the ability to cover off the no loss argument, a switch novation doesn't work. So there's no point pretending that it will, and there's no point consultants arguing that's what they need. So what will the market accept? The reason I've put that if it ain't fixed, broke, if it ain't broke, sorry, fix it anyway, is that some people seem to sort of go to huge lengths to amend novation agreements. You just need those 5 standard clauses. The market will accept, City of London Law Society will accept the CIC ab initio version, will accept bespoke forms. It will not accept the CIC switch form because it doesn't give the contractor the comfort they need. And if you're a funder or a developer, etc., it just doesn't work. So bear that in mind. With that, I'm going to pass you over to Rory, who's going to explain the different situations where novation occurs.
Hello. I'll just adjust this and get it slightly closer so I can actually change the slides. Now that Sarah and Andrew have finished boring you with the law, I'm hopefully going to lighten the mood slightly with a slightly more practical application of some of the stuff that we've been discussing here. Basically, that's going to take the form of running you through 3 different scenarios. I'll be really surprised if anyone on the webinar's heard of all of them, unless you're a lawyer. If you've heard of none of them, I'd also be very surprised, because there are some that are pretty common if you are, particularly if you're dealing with design and build projects. So let's kick off then with the most common scenario. So this is where you've got an novation of professional teams who are going across from an employer to design and build contractor. Andrew's already sort of alluded to when this situation occurs, and it is when you are engaging a design and build contractor to take on full design risk. The way that's typically done, if you're familiar with the JCT design and build forms of contract, is to basically make the contractor responsible for the employer's requirements. Those employer's requirements will inevitably have been developed and designed by a client-side set of consultants and a professional team. And where the contractor is taking on full design risk for those elements, he is clearly going to want to achieve 2 things. The first is to ensure that he has recourse against those consultants if they may, for some reason, have got something slightly wrong. And the second is basically to ensure that he can develop those designs post-contract with the consultant team who are already familiar with them. So he has those 2 aims that he's looking to achieve. And the way that he does that is hopefully to enter into a novation agreement with the employer, contractor and consultant that he wants to novate. It's always nice to see this expressed in a diagram format, so we have obliged and created some slides which show you how this works in practice. As you can see here, we've got a typical scenario on the screen of a pre-novation procurement matrix, showing that the employer is employing a set of design professionals who are helpfully highlighted in yellow. Pre-novation, they sit with the employer. Post-novation, those design professionals novate across to the building contractor. And by novate, we mean that an original appointment between the employer and the design professionals comes to an end, and a new contract on exactly the same terms is entered into between the building contractor and the design professional. Just to go back to this diagram, the arrow which is shown there is a warranty back to the employer, which I'll come on to talk about in just a second. So as Andrew mentioned earlier on, there's typically two types of novation which tend to be utilised. ab initio is the correct form and the obvious form to use in this scenario. Without that ab initio form of novation, then the contractor really isn't going to be best protected in the scenario that we're presented with here. From a contractor's perspective, we've listed here on the slide just some things that you need to consider. So the first is, what is the form of novation? And to that, we're getting to the fact that it is ab initio and does what it needs to do in terms of picking up those Blythe and Blythe provisions. The second is that when you're taking a novation, you are entering into an appointment on exactly the same terms as the original appointment that the employer entered into. So clearly, you need to read the original appointment. You need to understand it, and you need to be aware that there may be things like caps on liability, hopefully not net contribution clauses, but there could be net contribution clauses in there. So you need to be comfortable with the terms that you're engaging that consultant on. The third point is to be aware of actual limitations within the novation, and Andrew touched upon this. I've come to experience in the last couple of years that PI insurers are commenting more on novation agreements than they ever were in the past. They are relatively straightforward documents. You would hope that they are relatively uncontentious, but we have had circumstances where PI insurers are picking up on adjustments to those forms. So if you're inheriting a set of appointments from an employer who's unrepresented, there is a chance that they may have agreed to provisions that you as contractor wouldn't be comfortable with. So you need to be aware of that. The final point is in relation to the services. So this is just checking what the scope is for pre-contract services. Is that what you're expecting the consultant to have done? And secondly, what are the post-contract set of services, and is that covering everything that you need them to do post-contract once the novation has taken place? And it may be that, and what's common is to have some adjustments to those services and obviously the associated fees that go with it. But those are the sort of things that as a contractor you need to be aware of. We've got there the point about the collateral warranty. So what happens at the point of novation is that original appointment is extinguished. That means that the employer no longer has any recourse against the consultant he engaged. And so, one second, I'm just going to cancel a call. And so the employer needs to build back that contractual bridge, and he does that through a warranty. And if we're dealing with a consultant appointment, then typically the form of novation and form of warranty will all be pre-agreed, and so it'll be a case of populating those at the relevant time. So that's the common scenario, which I suspect a lot of you have come across. The second scenario is one that you may not have heard of before. So this tends to take place. So what we're talking about here is a novation of an enabling works contractor to a main contractor. And the types of projects that tends to come up on is high value projects or projects where there's some really complicated enabling works package, which means that actually a specialist contractor is probably better placed to carry out those works. And in that scenario, what the employer is wanting to achieve obviously is one, a single point of contact of responsibility. So someone who you can point the finger at if something's wrong with the enabling works or the main contract works. And secondly, he is looking for a lack of blurred lines between responsibility. So what he doesn't want is an enabling works contractor blaming the main contractor and the main contractor blaming the enabling works. He just wants to be able to get clarity as to who's responsible. And a way to achieve that is by novating that enabling works contractor across to the main contractor, and the main contractor taking primary responsibility for the work that's been done before he was involved on the project. Now, we'll come on to talk about the challenges in terms of forms of contract with the enabling works contractor, particularly on this in a second. But as we've done before, we've got some diagrams to give you a bit of an idea about what we're talking about here. So at the outset, you've got an employer who engages an enabling works contractor to carry out a package of works. The employer then employs a building contractor to do the main works. And at the point of employing the main contractor, we novate across the enabling works contractor so that he effectively, as you can see here, sits as part of the supply chain for the building contractor and sits at the same level as the other subcontractors who the building contractor is engaging. Now, one of the difficulties with this approach is obviously around timing as to agreeing with that enabling works contractor the principle of novation. So clearly, from a commercial perspective, you need to have quite early conversations with your enabling works contractor in order to pre-agree that they are happy with the principle of novating. And the second challenge, which is slightly more difficult to overcome without some help, is basically what form of contract you're going to put in place for that enabling works contractor. You sometimes see that clients will put in place forms of sort of trade contract with that enabling works contractor, but at the point of novation, if practical completion hasn't been achieved, it gets quite complicated as to how that all interrelates with the main contract, which is being put in place with the main contractor. So generally speaking, it's useful to pre-agree the principles with the enabling works contractor. It's useful to take some advice on what form of contract would be most appropriate. And in reality, the novation is best to take place after you've got PC of those enabling works. The only slight caveat to that is the fact that once you've PC'd your enabling works, if there are any issues, then clearly your enabling works contractor may not be quite so willing to enter into a novation if there are outstanding issues. But that's something that obviously can be covered off if you've pre-agreed the principles and captured that in a contract in some way. So the final scenario that we've got here where novation is sometimes used, and hopefully not many people in the room will have had experience of this in terms of being the actual contractor who's gone into administration, but where you've got a project that's quite close to finishing and you have a main contractor who becomes insolvent. The issue there is clearly that the employer is motivated to get the project finished. Ideally, he wants to get that project fully warranted, and so someone needs to take responsibility for the actions of the original contractor. And the point that we've made on the slide here is that just because a contractor has become insolvent, it doesn't necessarily mean that they've done a bad job on the scheme. And what you sometimes see is that a new Phoenix company is incorporated and created to complete a particular project. And if such a company does come into existence, what you can have is an novation of that original contract to the new company, so that new company can rely upon the works that have been done by the original company, and then is therefore happy to take on responsibility for the work that they've done. The reality is that without some sort of quite close relationship between that original contractor and the new co, it's pretty unlikely that any new co is going to agree to take responsibility for the work that's been done today. And one of the major considerations for the client will be around what he has to pay in order to achieve that fully warranted scheme, because at the point of insolvency, under most contracts, your obligation to make any further payments comes to either an end completely or certainly a pause until such time as you have clarity as to the overall costs. So the employer will be weighing up his options in terms of whether a novation is appropriate. But just to explain and to show again in diagram format what we're talking about here. So this procurement matrix we've got on the screen is a typical design and build procurement structure. You've got employer employing building contractor, you've got building contractor employing your design professionals and a suite of design subcontractors. That's pre-insolvency. At the point of insolvency, you then get this break of an individual coming out of that matrix, which creates a hole. At that point, you then need to get an administrator involved in the negotiation and agreement of entering into a novation agreement, as they are the only party that will likely be able to execute any documents on behalf of the insolvent company. And post-novation, what you then get is this picture of effectively a new building contractor slotting into the position of the old contractor. And hopefully the project will continue and finish seamlessly from the point of insolvency. Now, what you need to consider when you're dealing with this sort of scenario is obviously the same considerations around the type of novation. Ab initio, as we've said already and impressed upon, is the fact that is the only way to ensure that there's full culpability and recourse against the original party. The Blythe and Blythe clause needs to be in there as well. The employer, as we've said and touched upon, is going to be weighing up, does he really need one party to be fully responsible for all the works? It goes without saying that is clearly going to be a major motivation for him, but the costs of achieving that may be prohibitive. And so it may be a question of, well, actually, is it worth entering into this sort of arrangement and creating a novation in circumstances where we can just employ another person at less cost to complete the works without having to deal with a novation. That's something that will depend entirely upon the specific facts and scenario that's presented. But we have had scenarios where this has worked and it's worked well. We've got here a sort of disclaimer around TUPE. So where you are taking a novation of multiple contracts of an insolvent contractor, there is a risk that TUPE could apply, in which case you might need some help from an employment lawyer to make sure that you are fully aware of your obligations in relation to employees of that insolvent contractor. And then the final point here is, when we're dealing with administrators, what you tend to find is that they want to include in the novation a carve out on their liability, which is unusual when you're talking about a novation in the context of a design and build professional team to a contractor. But in this scenario, it's pretty typical. And in practice, an administrator and an outgoing contractor is not going to have anything to effectively pursue in any event. So it's something that you can readily agree to. So the final slide here to touch upon is basically around how you get yourself in a position where you can enter into novation agreement. There are, unlike assignment, where there are some implied entitlements to assign, there are no implied entitlements to novate. So the only way you can novate is either to have it written into your contracts from day one as to a pre-agreement to novate at some point in the future, or you just have to agree at the point at which you are forced into a position where that's necessary. Clearly, the design and build procurement team going across to a contractor is going to be pre-agreed in most circumstances, and certainly something that we would typically do. So you'd agree the form and mechanism by which that would take place. Similarly, as we've said, the enabling works scenario should be something that you can hopefully pre-agree. The only one that hopefully no one's looking to pre-agree is the insolvency situation, which unfortunately is just something that discussions that has to take place at the time to try and agree a way forward on that. I think that brings us to an end of our slides. I think we're now going to open the floor to questions, to which hopefully Andrew's.
Yeah, we've had lots of questions already. Also, should just make the point, I think Rory might need to come in if people want to see his head, but maybe that would be better if we don't. I just make the point, if you turn the screen, actually, we must get rid of the bag that has Will Ferrell as. Anyway. Right. Before we come on to questions, just one thing I just want to reiterate, and I've had it recently with a client. They were asked to take an novation of various consultants. They were a civil engineering contractor. They asked to see the appointments, didn't get them. And eventually, when they did get them, it consisted of one email. And that can work. That can work both ways. But it is really important that a novation is only as good as the underlying appointment. And if you don't see the appointment, then you don't know what you're signing up to. So without stating the obvious, I think we need to just sort of reiterate that. So we've had some questions in. I'm going to ask Rory and Sarah, and to a certain extent pick up some myself. I'm just going to pick up one that Paul sent right early on about an equivalent rights of defence clause. I can see the logic to having an equivalent rights of defence clause. You can see why you say that, but my view is that because it's novation, and novation is transfer, effectively you extinguish one contract but create a new contract. You don't need equivalent rights of defence because it's either in your contract or it's not. So I can see the logic for it, but I think that's actually dealt with effectively by the way the law deals with it. So just on assignment, one question is, what happens if someone tries to assign something where they are not permitted to do so? And anything to do with assignment gets flicked over to Sarah, so answer to that.
Well, essentially, the parties are free to prohibit assignment. So if if you've got a contract that expressly prevents you from assigning, then a legal assignment won't be valid. There might possibly be a situation where an equitable assignment arises, but certainly a legal assignment wouldn't be effective if the underlying contract prevented that from happening.
And for those of you dull enough to know anything about case law, there's a famous case called Panatown, all about a building in Cambridge. It's not actually about novation, but Panatown's all about no loss. And people were trying to assign stuff after the event and weren't able to. So it's sort of it's not dissimilar to that sort of issue.
And it's something that, ultimately is easily remedied. Whatever the contract says, it's just a case of being aware as to what it says and making sure that you take the appropriate steps to fix any issues around consent that you need to obtain and notices that need to be sent after the assignment.
Yeah, one for Rory. I mean, which professionals tend to get novated?
Yeah, so typically on a design and build project, you would novate the architect and structures predominantly. You do sometimes see the M&E engineer going across as well, but on most schemes, the M&E engineer will produce a performance spec and the contractor prefers to engage a design subcontractor in relation to the M&E element. So yeah, typically architect structures, sometimes M&E and sometimes landscape as well, for example, if there's a large landscaping package that's been developed pre-contract.
And there is a bit of an issue with novation. It's not because novation creates that contractual link, so the contractor ultimately could pursue a consultant for a pre-novation breach, assuming you've got the right word. But quite often a contractor doesn't want the particular consultants that the employer has employed. And that's not, sometimes they do, but sometimes you can get, and I apologise in advance for this, but you can get glory architects who are good at doing the planning phase, but are probably less good at the production information phase. And so novation is a way of creating the legal framework, but it's not often the best practical way. So you can find situations where you get novation of consultants, and effectively that consultant, their services are just stopped and an alternative consultant is employed by the contractor. Or you can also get situations where the contractor said, well, I want to employ my own consultants. The problem with the latter is that for the contractor to be comfortable to take on full design responsibility, they have to get their new consultant to check the old consultant's work, and they end up paying twice, or the employer potentially ends up paying twice. So it's not a perfect scenario because it does depend on the nature of the consultant and their relationship with the contractor and whether they're a particular contractor type consultant. So it's not as simple as novating it and that solves the problem, but it does work from a legal perspective. On an assignment one, this is a tricky one, Sarah, but have a stand. Funder assignments, are they legal or equitable? People may have got random pieces of paper that say your appointment has been assigned to a funder, and they're sitting there going, what exactly does it mean? So maybe you could have a go at explaining what it means.
Well, they tend to be an equitable assignment, and that is mainly a really boring legal reason, really. It's an assignment of a charge, and for there to be a legal assignment, it can't be an assignment of a charge. So essentially, it can only arise as an equitable assignment. The issue with that for the party trying to rely on the assignment is that they can't bring it in their own name, so they'd have to rely on the original employer to want to bring the claim, which of course they might not be prepared to do. So yeah, essentially equitable because it's a charge.
And the issue is, if you get sent one of those pieces of paper that says, by the way, so-and-so bank has taken a charge, equitable assignment or whatever of your appointment, it's not a particularly big issue. Arguably it's completely irrelevant for the bank because the bank already have rights over everything anyway. But certain banks like to have those, what you might call formal assignment type documents. You're often, as a consultant, asked to confirm that you agree to that. Again, it's a bit of a red herring because even if you don't, it's happened anyway. The reason you're asked to confirm it is because they're giving you notice. and it is definitely a sort of, and if you read the textbooks, it's not clear whether that would be classed ultimately as equitable or legal. It should be an equitable assignment because it tends to get assigned back again. But don't overthink it if you get it from a consultant's perspective, because it's just a piece of paper from the bank saying we're the bank and we own everything, which is basically true anyway. I've got one question I'll answer. Why does Carillion and Blythe apply in England? Well, on a very strict interpretation, it probably doesn't. Scottish law is not necessarily binding on English courts, but the problem is until we get an English decision saying what the position is, we are left with one decision only, and whether we like it or not. And in fact, I'm not sure the judge was completely nuts. But you would look at the wording and sort of slightly scratch your head as to say, why wasn't that good enough? But, you know, until we get an English case, then it will be persuasive and it will be what people refer to. And we've got one more assignment one just to make Sarah speak some more. What are the typical insurance arrangements on assignment? So what are typically insurance policies say?
Well, I mean, to the extent that there is a typical insurance policy, generally they tend to reflect the market standards to assignments without consent, with the usual carve-outs. But as ever with PI policies, you can't really assume that that's the case for all policies. They do all differ. So the only real way to know is to read the policy. Obviously, the risk with PI policies is always that, you know, if your policy says you can have 2 assignments without consent and you have 3, the first 2 won't be covered. PI insurers, you know, being usual insurers, will just say that no, you've undermined your policy, no cover. So it's just really important to check what the PI policy says.
Yeah, just to reiterate that, I mean, if you haven't checked your PI policy for a while, just check what it says on assignments. They don't tend to be particularly complicated, but they do. You know, if it says 2 assignments, you need to stick to it. Otherwise, you potentially put yourself in breach of the policy. Right, it's 11:59. Whether we have the final part of the trilogy of Dole talks, we'll see. But you know, Star Wars keep bringing out prequels and sequels, so maybe we will. Thank you very much for your attendance. Feel free to ask any questions if you want to afterwards. And we have this bizarre situation now where we press a button and we don't know whether it's gone off or not. It is recorded, should you be very odd and want to see it again. But we will send it around. And thanks for attending.
Thank you.